now. And the last thing I need to do is just run through the hearing script. This covers the procedure for the hearing, and then we'll jump right into it. So this is the October 12th, 2022 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati. I'll preside over this hearing. The case before us today is case number ZH20220150. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer reviewed evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the Zoning Hearing Examiner. All testimony and evidence that an applicant or the opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. For our purposes here today, I'll give Luke an opportunity to sort of take the lead on presenting this if he would like. Luke, as you know, I'm pretty liberal about how you want to orient your presentation. You can ask folks direct questions. You can let them testify on their own, however you want to do it. And of course, you can move your own arguments as well as you go through. Doesn't look like we have anyone here from the public. If we did, by any chance someone does arrive from the public, I'll give them an opportunity to testify after the applicant has presented its case. I will give our zoning administrator and the A House an opportunity to provide me testimony in addition to her staff report. Luke, I'll go back to you to respond to anything that's been said from anyone else during the hearing, and then make any closing statements. After all presentations have been made, I'll close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or make any comments. I may also refuse to consider hearsay. Generally, that's testimony you want to provide here today that includes the statements of someone who's not present. In the event of any technical difficulties with the Zoom tech, we'll do our best to troubleshoot that on the fly, but to the extent there's some defect that prevents us from me fully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay. Last thing to do is just swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, doing anything other than just strictly observing, they need to be sworn in. If you're not sure yet if that's you, then you can always wait until that time that you know that you want to testify. I'll swear you in later. I need you to be off mute, to raise your right hand and to answer out loud. The attorney is not it's not necessary to be sworn in. So if everyone can raise their hand, you solemnly swear that this what you give will be the truth, the truth.
I do.
Great. All right. Luke, are you ready?
I am.
The floor is yours.
Thank you, David. Let me start by just saying, sort of again, as is pretty much uniformly been the case for everything I've been involved with in the last few years. The staff really did an incredible job of sort of working with the team to sort of sort through all these issues. And I think that's reflected in the staff report, which, in many ways lays out the case even better than we did, frankly, as to why, no offense to us, but lays out the case incredibly well as to why this makes sense under the code. So I'll just be brief and defer in many ways to that report and encourage you to adopt it. But I think that there's two sort of real simple issues here. Big picture, of course, this is the practice facility, the Bengals practice facility down on Mehring Way. And we all collectively went through a pretty significant process to have the city granted notwithstanding ordinance to allow the construction of the facility, both notwithstanding the building code, but also the zoning code as it relates to the sign, among other things, the signs that are on the building. And so we started from this point where there'd been an extensive city process in which, if my recollection is correct, the administration supported the notwithstanding ordinance for that. And then, of course, the council, adopted it. And so there's sort of been a legislative finding that this structure is appropriate, and included in that is the signs themselves. And so we sort of were in this point today where there was this last little element of the code that was not explicitly withstood in that whole process. And I think
not just an oversight.
Honestly, I don't know if. So I think there's two possible versions. One is it wasn't clear yet how those were going to be lit, and then that was determined later. Another version is we did miss it and we should have tackled it then, but maybe there just wasn't enough clarity around, again, what I don't know for certain about that. And if we want to talk more about it, we can, maybe Randy might have a memory as well, or Emily, but I think certainly it would have been better to handle it then. But, I guess somewhat in all of our defense, there was a lot that was trying to be accomplished in a pretty short amount of time that was pretty complicated. And everybody did an incredible job making that work. And so I guess this is one of those future things that wasn't as much of a focus at the time. So that's sort of why we are where we are now. And so now, as you know, the facility is up. The construction is completed. The dome has been illuminated. I don't think there's a CO yet because there's still some more elements to be finished inside, is my understanding. But in essence, the construction is completed, and actually the signs are up as well. And this is for the light poles that would illuminate the signs. So big picture, I think, and this is why I think this makes, we think it's should be a straightforward call to grant the variance. This entire thing has been approved. Everyone agreed to it. The city council specifically approved it. But now we're in a situation where if you don't have these light poles, you can't actually light these lights. And so then you've got this whole entire thing that's been approved, but it's sort of got this one defect. That's a meaningful one when it comes to seeing them at night. So, what was that explained in the application, and I think what the staff report noted, is that two I think really, really important legal points as to the code. One is, given all the legislative approvals of this structure and these signs in particular, to then not allow signs or not allow the lights to go from 20 feet to 52 feet, which is what we're talking about here, would be, in our view, pretty unreasonably strict application of the code that would sort of defeat the purpose of all the outstanding warrants and everything else that have been done. And so we think that would be an unreasonably strict application. Somewhat along the same lines, it would, the sort of like, will it detrimentally affect the property right of the applicant prong of these arguments? In essence, these zoning codes, as you recall, this site is actually sort of split between two different zoning codes of RM and MG, but they both have the same rules as it relates to sign lighting. And those are these 20 feet limits on the heights for sign lights, light signs, sign lights, poles. And to have a situation in which, every other property owner who has properly permitted signs can light them, but then this one particular property owner can't, because of this unique circumstance of the sequencing of the legislative approvals, again, we think is an unfair, diminishment of their property rights. I think the other thing that I'd say that is important, and this can be one that folks can expand on more. Emily might be able to, but also with the team here if you need to. I think there's a pretty direct discussion around making sure, one, that the sort of impacts of the light on anybody else were minimized to the maximum extent possible. And so they've been designed to really, really be narrowly focused on just lighting up the signs and not having any other spillover effects to neighboring property owners and also to the bridge traffic. And so I think the staff report indicates that, the agreement with that, and the DOTE agreed with that. So that's one sort of proactive step that was taken to limit any impacts that are intended by, the point and part of these height limits is to make sure you're not spilling light into all these other places. And I think we've taken efforts here to make sure that's not the case. And then two, is there was this is a unique site in which it's a temporary facility. And so in flood events, there is one example, in flood events, there's a whole protocol that's in place to remove all of the stuff that could get in the way of flood movement, particularly the bubble. And also generally when the bubble comes down, the lights, the lights won't be directly next to the bubble anymore, they'd be further away from the ground. In both of those instances, there's a protocol in place to turn the lights off and disconnect them from electricity, so there's no risk safety wise, and also the light impacts you don't have to worry about light impacts when the bubble's not up, because there will be no lights when the bubble's not up. So I think those together are the big picture points, like the satisfied legal argument, but also I think just commonsensically argue for why this should be granted. And then I think, it's in our application, it's in the staff report, all the elements around the sort of public benefits and private benefits that we won't go into detail with here, but I think are pretty self-evident. So that's all I have, and I think I think our team will be here to answer questions, David, if you have them.
Sure. You mentioned DOTE. Have they reviewed this?
I can let Emily step in on that, but I know that the staff report indicates they did review it and approved, or it didn't have any concerns, I guess is maybe a better way to put it.
Okay. So, yeah, Mr. Schultz, are you able to add any more to any technical information on the lights themselves? I assume these are LED lights, and Mr. Blocher mentioned that they were designed to only illuminate the signs or to have a narrow sort of scope. Can you talk more about that?
Yeah, that's correct. The light fixtures that were selected and are identified, they'll be focused on the signage areas to minimize any light spillage. And then as part of the study, it was reviewed as the reflectiveness of the lights off of the structure, and then the impact that, to verify that any impact to surrounding properties would be minimal. And so that's been, that documentation was included in this.
Is there any adverse impact? I mean, maybe the bridge is there.
No, it was the light amounts they're negligible. As it was mentioned, looking at surrounding roadways and things like that to make sure that that there's no negative impact there. But yeah, that was the findings in our opinion, is that no adverse effects on surrounding properties.
I'm not sure that I have too many more questions right now. Emily, is there anything you wanted to add? And can you comment on the DOT?
Yeah, well, I do want to just clarify for the record that process-wise, since the use and the signage and the building were approved by the notwithstanding ordinance, when we received this request, I did consult with the law department just to make sure that it was, appropriate to review this independently and didn't need to go back to council as an amendment or alteration to the previous approval. And they did confirm that this was the appropriate path forward for the request, and there was nothing prohibiting a request for lighting in the initial ordinance. So just process-wise, this was determined to be the appropriate process. And our findings is it's a unique type of structure where you can't easily affix exterior lighting to the structure for the signage. Exterior illuminated wall signs are permitted in the MG and RFM zoning districts. So the ability to light the signage is a substantial property right enjoyed by others in the same zoning districts. The lighting as they propose it is focused on the signage when the dome is in place. They have provided the photometric study, which shows minimal light spill beyond the property. The Department of Transportation and Engineering did review that light study and did confirm that they have no concerns about light spill to the bridge or the right-of-way from the lighting based on the evidence that was provided by the applicant. They have stipulated that the lighting will be off when the dome structure is removed. So I did just include that as a recommended condition of approval to make sure that that's encapsulated in the decision. But ultimately, even when the dome structure is removed, the height of the light poles is similar in height to your typical stadium lighting. So from an aesthetic standpoint, even though the light poles will remain around it, it will have that appearance of a football field with 60-foot light poles. And we've been seeing in other stadiums variances for 60 to 70-foot light poles going around football fields. So just aesthetically, it will have that same appearance.
If based on your interpretation of the code, if these were able to be affixed directly to the structure to externally illuminate the signs, would they be permitted by right? Or would they still need?
We would permit it by right because it would be the signage lighting. We wouldn't consider it exterior lighting.
Gotcha.
The height limitation.
So the height limitation is only when there is like independent poles or structures that lift the lighting above 20 feet.
Right. And I think the intent is for like parking lot lighting or lighting that's shining out from a building. And
Gotcha.
it doesn't contemplate a
The
circumstance.
idea is just to reduce the amount of pollution or
Yes,
excessive light on adjacent properties.
yes.
And you believe that the design of this accomplishes that goal despite the height?
Yes, because the lighting is focused to the signs, not outward.
Okay, thanks, Emily. Anything else?
Nothing for me.
All right. Luke, anything in response to that or otherwise in closing before we adjourn?
No, I think you can probably just take what Emily said and ignore what I said, and you go from there. No, but I appreciate it. That was well said, and I think all the points about have been hit on. Why this is necessary, but also why it really is consistent with the point of the code.
And to confirm, Luke, you're saying that the lights will not be operated whenever the dome structure is down.
I want to let maybe Randy speak to that directly, but that was my understanding of sort of some of the discussions that had been going on ahead of time around the concerns that were voiced by the city.
Yeah, but one of Emily's recommendations is that the light poles not be operational when the inflatable dome structure is removed on a seasonal basis.
Yeah, Luke could speak to the owner's intent with that better than I could, but I mean, there's nothing that we see from an operation standpoint to where that would be an issue.
So I guess put another way, the lights aren't going to be used to illuminate field inside for them to practice on when the dome's not up. Or are they going to practice on this field when the dome's not up?
I don't think there's any, the dome is there to have indoor practice facility. It's not there to be, an extra outdoor practice facility. I don't, is always been our understanding, and certainly not. It's there's other outdoor practice facilities that exist for that reason. So, I think the point here is to make sure we have everything in place for the, the normal operation of the indoor facility, but also then the proper illumination of the signs that were, because this is about the illumination of the signs. That's the goal it's accomplishing here. These lights aren't even like, well, I don't know. Their purpose right now is to illuminate the signs. That's what they're designed to do.
Got it. All right. I think we'll leave it at that then. I've had a chance to review the application. I haven't reviewed the NWO. I'm curious to do that. Maybe that before I actually formalize my decision in writing, but based on the staff report, the application materials, and the testimony here today, I'm going to approve the application. Like I said, I need to put that in a written decision, as you know, Luke. Review that NWO, just so I may include some details from that. But that usually takes about a couple of weeks. I'll try and get it to you as quickly as possible. Let's see. As soon as I finish it, I'll put it in a PDF. I'll email it to everyone here in the hearing, so you'll have a copy of it really just moments after it's complete. Again, as we can start working with our departments, we have that to get the permits. Let's see. Any questions about any of that so far?
Well, first of all, thank you. We appreciate it. Second, I'm not sure if Randy or Jake or anyone on the call has any sense of sort of whether that 2-week time frame has any impacts on plans for when those lights would need to go up or anything like that. I just don't know if there's anything material that we would require. If there's any earlier dates that would have a material difference, it would be good at this time to at least let David know about those.
I do not. I'm not able to speak to that, Jake. I don't know if you have any input there.
I will. Yeah. Go ahead, Mr. Warren.
I don't believe so. I think that it's fine.
And just to clarify, I don't believe you've applied for a building permit for this yet for the light poles. You can always go ahead and apply and get all the other reviews on it so that the last review is zoning when we get David's decision.
Thanks. Guys, I'll try to expedite this and get it to you as quickly as possible.
Thank you. Really appreciate it.
Tweaks is sort of a silly one I can throw out there just in case. Test goes on this stuff. So, all right. If you want an update on the status of that decision, Luke, just send me an email. I'll let you know where I'm at. Okay.
Okay, great.
You're otherwise, and there's an increased sense of urgency. Just send me an email. And let me know. Okay.
Great. We appreciate it very much.
All right, guys. Thank you all for your time, your testimony. Appreciate it. Good luck with the project. Hope you have a good day.
Thank you. You too.
Thank you.
Thank you.